Our next speaker is Joanna McDavitt, who is representing Just Speak. I found Joanna by asking around where I might find a young, passionate speaker interested in the rule of law. It didn't take long before I had her name. Please welcome Joanna.
Also quite clumsy. That's all right. The Magna Carta that we celebrate today, I imagine, is quite different to what the barons thought they were signing up for 800 years ago on the fields of Runnymede. On convincing King John to sign the Magna Carta, what the barons did is they ensured for themselves a bigger slice of the pie that was power in Great Britain at the time. They had more control over their own assets, essentially. They didn't have to worry about tax so much, and they weren't compelled to build bridges at riverbanks anymore. So that was the agreement that the barons signed up to in 800 years ago. With that background, you have to wonder if those barons thought that they would be signing a document that 800 years later would be hailed as the cornerstone of our constitution of New Zealand, a country that they didn't even know existed at the time. And I point out that background to say that the Magna Carta wasn't really intended to be a document that gave power to the powerless or a voice to the voiceless. Essentially, it was about a struggle between barons and a king, between a man who had immense power and a group of men who also had quite a lot of power as well. So, in terms of the challenge today to look at the Magna Carta in a new way, that's my perspective on it, is to think about the history of the Magna Carta and the fact that it was essentially about power sharing between those who had power, and the challenge of making that relevant to a broader population in New Zealand. And I found it interesting what Patrick Riley had to say about the idea of the Magna Carta as Britain's greatest export, because that's another facet of what's going on here. So the Magna Carta, of course, is, for us, a colonial import. It's part of a justice system that isn't native to this land. But that's not why we're celebrating the Magna Carta today. We're celebrating the Magna Carta because, as we've heard, it's acted as a foundation for many of the principles that are vital to the health of our constitution and of our representative democracy. Principles like access to justice, right to a fair trial, the rule of law, freedom of religion. The Magna Carta has become a powerful symbol to build up all of those principles that our ancestors battled to entrench. But of course, none of those principles sprang into being overnight, and that's another element of the history of the Magna Carta that we should be aware of when we think about the place of the Magna Carta going forward. They took time to grow through legal precedents, through lawyers and judges drawing different points from them for different cases and for different purposes. The Magna Carta provided that the king should be advised by the barons and the bishops, and over time that became the principle that it's the parliament that has power, has lawmaking power in our society, and not the monarch, not the executive. And drawing on something that Andrew Little pointed out, that's a shift that has happened quite slowly, really, over hundreds of years, and it's a shift that has been born out of uprisings by different groups of people who stood up for their rights and stood up and said, no, we want more power in this situation as well, until we came to the situation which we have here, which is a parliament that has supreme lawmaking power, but still perhaps leaves some out in the dark. And that's what I want to talk about today, is about how we make the Magna Carta relevant to people who have traditionally been left out in the dark, how we give the voiceless a voice, and how we give power to the powerless. If we think about the way that the Magna Carta is talked about today, we see that if we don't rise to that challenge, it's at danger of becoming a relic of the intelligentsia, something that the middle class talk about while they drink their tea. And I mean, the makeup of this panel tonight is maybe an exemplar of that. I think I'm probably quite safe to say that I'm the only person under 30, shall we say, on the panel. I'm the only member of that minority group we call women. And the panel tonight it's whiter than our judiciary, which is 93% white. So we're not doing great on that front there. So how can we move on from that? How can we make the Magna Carta relevant to those who don't usually sit down and think about the deep constitutional questions, probably because they're working 3 jobs and they've got 3 kids to look after? There's many answers to this, but I want to focus on 2 points in particular. The first thing I want to talk about is prisoners' voting rights, and the second thing is access to justice, both areas which come back to key principles in the Magna Carta. So on prisoners' voting rights, since 2010, if you're in prison in this country, you can't vote. You don't have the right to vote. You don't have the capacity or the ability to exercise that core civil duty. Some of the work that we do in Just Speak is talking about how we need to make sure that our prisoners are part of our community, that often the reason why people end up in prison in the first place is because they feel isolated from the broader community, and that people, if they are not reintegrated into communities, will only end up back in prison. But when we take away that core civic responsibility, like what message is that sending our prisoners? We're not sending our prisoners a message that we want them back in our society. We're not telling them that they're valued members of our society and that they have a role in decision making and in making choices for themselves. We really undermine the kaupapa of a lot of what goes on in the justice system to try and make sure that prisoners, when they are released back into the community, because we don't just throw people away and that's it for the rest of their lives because they were found with marijuana one time. If we want successful outcomes for them, then we've got to find ways to make sure that they feel part of that community again and they feel empowered as part of that community. And so that's my first challenge, is start talking about prisoners' voting rights. Start advocating for our prisoners, because if we don't want to become a prison state, which we're quickly becoming, then we need to recognise the humanity of the people behind bars in this country, and taking away their right to vote is contrary to that humanity and is contrary to the basic principles of the Magna Carta. The second thing I want to talk about tonight is access to justice, and this is an area which has become there's a lot of talk around this topic right now, particularly within the legal profession, after Justice Wynne-Kelman's challenging Ethel Benjamin address last year, which talked about right to access of justice, particularly in civil cases. And of course, some of the core principles of the Magna Carta and its relevance today in our constitution and legislative setting through Chapter 29, which we've heard about already tonight, is ideals of access to justice and right to a fair trial and equality before the law. But you can't have access to justice and right to a fair trial and equality before the law if we have a user pays justice system, if you can't get into the courts even without having thousands of dollars of money sitting in the bank. And that's the case now. We have a legal aid system in this country. We recognise that legal costs are out of reach for many, but government funding for legal aid has continued to decrease. Not only has it not been increased to keep up with inflation, it has actively decreased budget to budget over the last few years. Furthermore, eligibility for legal aid has been significantly restricted. I'm not positive of the figure off the top of my head, but for civil cases, I think it's, for a single person, I think it's something like $22,000 a year. If you're earning any more than $22,000 a year, you don't have access to legal aid. And people on legal aid, be it civil or criminal, except for the most serious of offences, don't have a right to choose their own lawyer. They just have to put up with whoever they get given. But the whole basis of that relationship between you and your lawyer is based on trust and confidence. If you don't trust your lawyer, then there's no way that your lawyer can represent you effectively. If you don't trust your lawyer enough to tell them about your mental health issues, which underlie the reasons why you're offending, then there's no way that that lawyer can represent you efficiently. And that's the system we find ourselves in today. And on the other side of the story, lawyers are finding it increasingly difficult to operate at all within the legal aid system. Noel Sainsbury, who's a member of the Criminal Bar Association, estimated in a recent Law Talk article, and Law Talk, sort of the trade journal of lawyers, that a lawyer operating on a simple one-day trial in the High Court on legal aid would make about a $3 profit from that. So $3 for a day's worth of work. It's not that it's not profitable to be a lawyer in the legal aid system, it's just that it's not feasible anymore. Furthermore, we've moved from a charging by hour system to fixed fees, which means that the incentive is to get a case over with as quickly as possible, so you can fit in as many cases as possible into your day. And what's the quickest way to finish a case? Get your client to plead guilty. So that's the criminal side of things. On the civil side of things, things are just as bad. So a simple one-day hearing in the High Court will set you back about $7,000 all up. And that's in court fees alone. That's before you talk about hiring your lawyer. So that means it's just impossible for many people to access our court system. But our courts, again, touching what Andrew Little has said, play such a core role in holding our government to account in our constitutional system where we're supposed to have power against our lawmakers. So judicial review, for example, is a core part of our public law toolkit. It's the way that we as individuals can challenge decisions made by the government that affect us. But if it costs $7,000 just to get into court, then imagine if you, as a disability beneficiary, WINS decides to cut your disability benefit. You're not going to judicially review that decision. And so on the one hand, we have Parliament taking increasing powers for itself, and on the other hand, traditional methods of challenging those powers are being undermined because they are becoming unaffordable. And so to sum up tonight, the challenge for the Magna Carta going forward is to become relevant for more than just people who already have power, more than just people like you and me, who are educated, who are brought up in good homes, who have the good fortune to be white in a society that privileges whiteness. The challenge is to use the principles of the Magna Carta for people like us, people who have that political and social power, to speak up for people who don't, to speak up for our prisoners, to speak up for our beneficiaries, to speak up for people who don't have the money or otherwise the ability to give the time to these sorts of issues. Moving forward, that's the challenge for the Magna Carta, and I think it's a challenge that I make to all of you here today. Think about how you can use your position of influence, be it just among your friends group, be it among your professional network, to advocate for those that don't have the power to advocate for themselves. Thank you.
Thank you very much. Thank you very much. Like you, I feel privileged to have listened tonight to 4 different and rich visions for the future drawn from the legacy of Magna Carta. Chris picked up themes of legal pluralism, while Patrick talked about the extension of the international rule of law. Andrew argued for a stronger Bill of Rights, while Joanna argued for extending the effective protection of the law to marginalized groups, including prisoners and those without the deep pockets needed to obtain the rule of law.